And good afternoon. It's Tuesday, March the 12th, and you are here for the Family and Juvenile Law Subcommittee meeting. We have one bill, and that is HB 745 that we want to go ahead and tackle. And I'm going to start off with an amendment we have. And if our counsel will go ahead and read the amendment and explain it to us, and then we'll take it from there.
Sure. So we're back to working off the bill as introduced, not the amendments from yesterday. So the bill is introduced, just a reminder, it expands eligibility for a protective order by altering the definition of person eligible for relief to include any individual who alleges that the respondent within 6 months before the filing of the petition committed stalking against the individual. And it also repeals existing law governing the issuance of permanent protective orders and establishes new circumstances for the issuance of a permanent protective order. The amendment just makes one change on page 3 of the bill relating to the issuance of a permanent protective order. It strikes references to crimes of violence and stalking. So the language would now read, one of the criteria would be that a permanent protective order can be, or actually is required to be issued against the respondent if an interim, temporary, or final protective order has been issued against the individual and the individual was convicted for an act of abuse against the person eligible for relief.
Okay, thank you very much. And does the subcommittee have any questions regarding the amendment and what it does? Okay, doesn't look like it. I don't see any hands. Okay, so is there a motion on the amendment?
Move the amendment, Madam Chair.
Okay, and is there a second? Okay, great. And so we'll do a hand count on the amendment. So everybody in favor? Go ahead and raise hand.
Aye.
All right, great. All right, anybody opposed to the amendment? Okay, that's great. All right, now on the bill, okay? And so the bill was really explained, I do believe. And are there any questions or discussion on the bill?
We've got a bunch of that, so I'll just say, now.
Please mute.
Madam Chair, if I may.
Yes, yeah, hold on, someone's on, oh, Delegate Sample Hughes, there we go. All right, go ahead.
Sure, I just had a question for you. I just wanted to make sure I was understanding correctly. What we just voted on, was that Shelley's amendment or Cardin's amendment?
Nobody's amendment except
nobody's amendment,
except for it was introduced by us, the committee. So we brought the bill back to its original intent. So that was not the sponsor's amendment, if that's what you mean.
Okay, because we've gotten several amendments and I printed off a lot of them, and so I was just double checking.
Well, you should only have one right now, okay? And that is,
okay.
Let me see, it starts, it's amendment 3733291.
Delegate Semple Hughes, I think you may be referring to Delegate Hardin's amendment in the Criminal Law Subcommittee and may have gotten confused.
Yeah, so this is
no, it was
HB 745, and the only amendment should be 3733291.
Got it. Thank you.
Okay. Sure. And do we need to explain it again, or there we go? That's the amendment. Do we need to explain it, or?
No, that's okay. I got it, and I've got the differences now.
Okay.
All right, all these are starting to run together, but thank you kindly.
Understood, and that's why we did what we did. I think we had a lot of amendments yesterday. So now just going back to, I think, the goal of what the bill is. Delegate Simpson, you have a question?
Yeah, so this went back to the original form, right? Of the bill and then amended. And who asked for the amendment?
I did. I asked for the amendment.
Okay.
To clarify it and to put it back into what the sponsor's original goal was with the bill.
Okay, and
Okay. And so let me do this. Lauren, do you want to go back through and just explain now what this bill really does with the amendment, et cetera? I know you've explained it, but would you mind doing it one more time for us?
No, I don't mind. It's expanding eligibility for protective orders. And the way it does that is it's altering the definition of person eligible for relief to include an individual who alleges that the respondent within 6 months before the filing of the petition committed stalking against the individual. And it also repeals the existing provisions governing the issuance of permanent protective orders and establishes new circumstances for the issuance of permanent protective orders.
Okay, and so can you give us the detail of what and how you can now issue or be in a situation where you can get a permanent protective order?
Sure. So that's on page 3, and the court is required to issue a permanent protective order if 1, an interim, temporary, or final protective order has been issued under the law against the respondent. Number 2, the respondent was convicted for an act of abuse against the person eligible for relief. And 3, the victim of the act of abuse, who was the person eligible for relief in the prior order, requests issuance of a permanent protective order. And then the remaining provisions, 2 and 3, there, starting in line 28 through 33, are basically the current law, just reproduced.
Got it. Okay. Any other questions?
did we hear from our, I guess, the advocates what their thoughts were on the amendments, or did they help you draft it?
Yes, all of that. So in fact, what happened is yesterday, as you'll recall, oh yeah, let me do something else real quick before I get there. We do need to reference the act of abuse in here. Lauren, do you want to talk about that real quick?
Sorry, are you referring to
Yeah, to
the
K
change
2.
on line 22?
Yeah, on page 3, line 19.
Right, so that is the only change to the bill as introduced. You'll see that. It came in with a conviction for a crime of violence or stalking. And it was felt that it was better to have it a little broader to include a conviction for an act of abuse against the person eligible for relief.
Right. Okay. So getting back to what happened with the bill. So yesterday there was a lot of confusion about what was really happening with the bill. And in talking with the sponsor a little bit more, I made an executive decision that I think that it would probably be a good idea for us to go ahead and start back from the beginning, the original intent of the bill, which the sponsor was happy for us to do, which was to actually just expand this to include stalking. Okay. So that's what happened. And then also I did talk to the advocates. And by the way, the advocates are here. The only one I didn't really talk to was Ms. Shapiro, but everybody else I think I spoke to.
Yes.
Uh-oh. Somebody, yeah, can they mute themselves? Okay, go ahead. Did you want to speak, Ms. Shapiro? Uh-oh, you're on mute.
Sorry about that. I'm doing my phone and my computer.
Gotcha.
So I actually opposed this bill as it was drafted. And so if the amendments are not in, we supported it being moved with the amendments to the peace order. And so I'm just seeing this amendment for the first time. I had done a survey of 37 states that have stalking in their peace order, or how address stalking in a civil order. And 33 of them actually keep it separate. They separate out domestic violence orders because they have certain kinds of relief and unique protections. So I thought that the amendments we worked out was how we were supporting the bill. I'd need to look at these amendments that are being submitted, but we think that the protective order should remain as is and keep this the non-intimate partner category in a different order.
Got it. But part of the problem too was that we were really being very expansive, okay, with the peace order. I mean, the peace order is supposed to be for, like you mentioned earlier, for individuals that may not know each other, et cetera. And I understand that, you know, typically we've attempted to keep them separate. But I think really when this, and I'm sorry, I'm going to speak out of turn here, but speak on a little bit on behalf of the sponsor as well. And that is that originally what she wanted to do was to expand it in the protective order. And I don't see why later on we can't come back and do something with the peace orders as well. But I think right now, probably the best vehicle is to keep it the way it is, so that it's clearly understood and we don't get into, you know, what we were doing, which was really expanding both and getting way beyond what the original intent was of the bill.
Yes, and sorry, not that mute. And you know, I don't think that I'm saying anything that I have not shared already with the sponsor, and I had it in my written testimony. There were other people who were similarly postured. There's great concern of what would happen to, you know, there are certain protections in the protective order and other efforts to expand protections for victims of domestic violence that we are concerned could be impacted if we expand the order of protection to include other categories. Overwhelming, like 40% of intimate partner violence or 40% of stalking victims, it is intimate partner violence, and that is covered already in the protective order. So our position in terms of the bill was we supported the amendments. We did have issues with the bill that as it was drafted, including it in the protective order. And I believe that there were others that submitted testimony on the bill in the same vein, saying the same thing, that we supported the bill with the amendments only.
Okay. All right. Well, like I said, unfortunately, I think that for right now, this may be the best way to do it. I think it's still, go ahead, Ms. Jordan. Thank you.
Thank you. You know, I certainly the Coalition Against Sexual Assault and the Coalition Against Domestic Violence work together quite a bit. I do think that we've always taken the position that either amending the peace order or the protective order was acceptable, and really don't see the protective order as exclusively intimate partner violence, because we do have non-intimate partner sexual assault cases that are covered by the protective order. There are also some child abuse cases, and there are elder abuse cases that that involve physical violence where people are not related at all. So I don't view it as a particularly exclusive purview of domestic violence cases in the protective order. I also have to say that the improvement to the permanent protective order made by these amendments is just enormous. It's very difficult to get a permanent protective order. They're very restrictive requirements right now. And in particular, to say that here is a respondent who committed an act of abuse and not require that it be tied back to the protective order, that is huge. It's really helpful to have the removal of the requirement that it be at least a sentence of a longer period of time, and just allow us to have a permanent protection for people who have committed abuse and been convicted, criminally convicted beyond a reasonable doubt. So that is something that that we really appreciate. And I will just say, having listened to this conversation for a while, I just want to observe that by adding stalking into the protective order, it does address some of what this committee has discussed before, in particular the filing fees issues and the catch-all the catch-all provision is in that protective order. So when you move stalking there, that is there as well as the time to file in a protective order is not restricted the way it was for the peace order. So I hate to disagree in any way with my sister coalition, but we do find this to be a reasonable compromise, and certainly are comfortable with the decisions that the chair has made in this regard.
Okay, and I don't know if our assistant state's attorney who's on board might want to have any comments regarding
Hi, good afternoon.
the bill.
Thank you so much, Chair Crutchfield. Again, also from the beginning, our position has been that we believe that non-intimate partner stalking cases should get additional protections. I have been, I've heard both positions, protective order or peace order, and the civil component is really not directly in the lane of the state's attorney, but certainly.
And again, and I appreciate, Ms. Jordan, you mentioning the cost factor, because that was a question earlier, that the peace order, of course, has what was it, $85, $83 cost on it. So I think all of those taken in consideration probably, again, create the protective order as the right vehicle to use in this instance. Is there any other discussion about the bill and amendments? Okay, it looks like everybody's okay. All right, then what I think I'd like to do is take a motion on the bill, if there's no other discussion.
Move favorable, Madam Chair.
Okay, and is there?
Second.
Okay, and now is there any more discussion before we vote on this? Okay. All right, seeing none, then we're gonna go ahead and we're gonna do a roll call vote on this. So Delegate Bartlett, Vice Chair Bartlett, go ahead.
I'm ready to vote in favor. I just was just asking Ms. Shapiro a question, and I kind of want to hear the answer. We were texting, but I wanted to hear the answer. If Ms. Shapiro could elaborate. My question was, what are some of the protections that you feel are not available with the revision as it stands now for the domestic violence community?
Sure. Well, so there's.
Uh-oh, we can't hear you.
Sorry,
go.
I keep hitting the wrong
It's
unmute
okay.
button. So I think that there are some practical matters first. One is that right now there's sort of and there are some non-intimate partner, as Ms. Jordan indicated, the sex assault is in the protective order, but even in the other cases, there is a familial connection, generally speaking. And then, so just for people going to a courthouse and knowing which order, it's sort of like you have this relationship, you get a peace order, you don't have this relationship, or you do have the relationship, you get a protective order, you don't have the relationship, you get a peace order. So there's just the practical nature of that, the court knowing, so that there's that. And then I do believe, I don't want to speak out of turn, I do believe the Women's Law Center and maybe House of Ruth in Maryland submitted I don't know exactly what position they took, but I believe we were taking the same position, that we supported the bill with the amendments that were there, taking it out of the protective order. There's a lot of protections in there. For example, removal from somebody's home, child custody decisions can be in the protective order, support, dealing with pets, all sorts of things. And so as we amend and improve the laws for victims of domestic violence, the concern is that then we're going to have this other category of individuals that are going to be eligible for the same relief. So for example, Delegate Bartlett, you and I have this firearm background check denial. We're now going to include a category of individuals that previously weren't included in the protective order. And so as we, for example, improve other legislation, we're going to have to say, but there's these other people in here too, and they're going to be getting the same protections that are designed for victims of intimate partner violence because of the risk of lethality or the nature of the relationship, that is not necessarily going to apply in a situation where people may not even be really known to one another. And so I appreciate what the delegate is trying to do for victims of stalking, and it is a very serious issue, but we believe that it's best accomplished, as many of the other states have done it, through a different line and through a different, through the relief eligible through the peace order, which does have the stay away language. I think the amendment allowing the discretionary removal of firearms, all of those other things are appropriate. I think the length of the peace order, all of those, that is consistent with what many of the other states have done. And I will say that there was a lot of concern from the domestic violence community with the original drafting of this bill, which is, why I've been on ongoing communication with Delegate Shetty about the amendments and worked on the amendments very closely with Delegate Shetty to get the bill to a place where we would in fact support the bill.
Okay, thank you, Madam Chair.
Go ahead,
May
Vice
I?
Chair. Yes.
Thank you. So, I understand what you're saying, Ms. Shapiro, in part. I think that, I agree with the chair of the subcommittee, though, that we can move forward with the bill that is before us, and we can also do more, on the next go round. Because I think that the way it is before us now will actually help a significant amount of people, and I know, you know, that's always the goal. So I think that it does make sense. I agree with the chair to move forward now, and then, you know, we can do more on the next go round. Like we always do. We always do more the next go round.
That's right. We learn.
Yep.
And keep it moving. Definitely. Okay. Any other discussion on the bill and the amendment? And Ms. Jordan, I saw you had your hand up. Well, kind of had your hand up. Did you have a comment as well?
I did. Thank you, Madam Chair. I just wanted to briefly say, just as a point of clarification on the law, that if you do not have children together, there is no custody order. If you do not have a pet together, there is no order regarding pets. If you do not have a financial obligation to support someone, there's no emergency family maintenance. So I do think that the committee should be comfortable saying you could move stalking into this category, and that would not create some sort of risk that you'd have inappropriate orders. You know, obviously the other points are things that we may just differ on. But just as a matter of law, I want to make sure that was clear.
Thank you. I appreciate that very much. Okay, any other discussion? Any other questions? Okay, well, I think what we will do is go ahead with our roll call vote on this. All right, so we'll start with Vice Chair Bartlett.
Yes.
All right, and we'll go to next Delegate Kaufman.
Yes.
Delegate Boucher.
Yes.
Delegate Valentine.
Yes.
Delegate Simmons.
Yes.
Delegate Sample Hughes.
Yes.
Delegate Tomlinson.
Yes.
Delegate Pastor.
Yes.
Delegate Taylor.
Yes.
And myself, I'm a yes. Okay, I think that's everyone.
How about me?
I'm sorry?
How about me?
Oh, you know what? My apologies, Delegate Pastor. You know,
No,
I don't have my list of names in front of me. I'm going by the little square.
No,
It's Simpson.
No.
Oh, it's Simpson. I'm sorry, Delegate Simpson. Oh, no. I'm trying to go. My apologies, okay? Delegate Simpson.
Yes.
All right. She got her special yes.
And Valentine.
Thank you. Thank you. Thank you. Well, I appreciate you guys staying late doing this, and we are done. Our subcommittee is done, I do believe. Thank you so much. And it was a unanimous vote. Thanks again.
Thanks, everyone.
All right.
Good night.
Bye.